Can you see me? I can see you, but you look really far away. Maybe you're keeping your distance because you know that this presentation on 10 actual estate plans probably is not worth looking at. I am here in the Gassman studios, and the cameraman is really, really far away. There, let me see if we can change the view here. All right, there we go. So, for those of you who are interested in learning about estate planning, I recommend that you go to YouTube and watch something other than this. This is not a very well rehearsed presentation, and I've seen most of the slides. In fact, I produced several of them. And by the way, this is only for wealthy people. If you're not wealthy, please do not watch this presentation. Or if you are wealthy, but you might not be wealthy later, then I wouldn't watch this presentation. The presenter, Alan Gassman, has not rehearsed the presentation and quite honestly is pretty mediocre when it comes down to it. Nevertheless, and 7 minutes ago, we planned the presentation, and I hope that it is much better than this introduction. So, without further ado or anything being due, here is our presenter, Alan Gassman. Alan? Oh, hello. Your lips moved. Stop that. Well, my lips have to move. I'm talking. Oh, don't talk to me. All right, I won't talk to you. You're gone. Okay. So, welcome to today's presentation on 10 estate plans. Quite honestly, I had to struggle to decide what estate plans I was going to share with you. So, as always, I have more or less than what I was originally going to talk about. I've got a PowerPoint, I've got some computer programs, I've got some Excel spreadsheets. If you have any questions today, you can email me at agassman@gassmanpa.com, which you will see on the screen in just a second. And let's remember that in 1 hour, I can only scratch the surface of what you may need to know for your own estate planning or for your estate planning practice. But I hope that I'm going to cover some important things, hopefully some things you haven't thought about or seen before, or some things that you've thought about or seen before but may not have been on your checklist or on your radar. We have a wide assortment of viewers here. Many viewers are tax lawyers and CPAs, and many viewers are people who are just interested in estate planning or maybe puppeteering. So whatever you're interested in, I hope that you will find it, and thank you for your tolerance as we search for the right combination. So I'm going to go ahead and get on my computer here and move my camera over so I can see what I'm doing. You should see my screen here, whether you want to or not. And welcome to Saturday, July 30. If you have a question, if you prefer not to email, you can hit the inverted pyramid, sing the Cleopatra song, King Tut by Steve Martin, born in Arizona, raised in Babylonia, King Tut, I think that's how it went. So type your question in. If I know the answer, I may answer it. Otherwise, I'll pretend not to see it. This presentation does not qualify for continuing education credit. As I've said before, it's simply not good enough for that. Next week, I will be running the numbers on estate and charitable planning techniques with real situations and real numbers. And then Saturday, the August 13, we'll talk about the fundamentals of estate tax planning. You'll keep attending these webinars until you get them right. Our last Thursday report had some interesting articles. Feel free to pull up or just Google Thursday report, July 7, 2022. We issued the Thursday report.
every once in a while, usually on a Thursday, but not always. Okay, we do have a YouTube library, and the first row across, you will always be able to see a lot of estate tax and estate planning presentations, and then the other rows have different themes, a lot of charitable planning, which is always very interesting and good for people. Next week, I will be demonstrating our spreadsheets and spending more time on spreadsheets and on the Estate View software to give you a view of Estate View, and we may get to that today. One never knows exactly how long all of this takes. But I'll skip the spreadsheets. If you're interested in the spreadsheets and you don't want to wait until next week, you can just Google Gassman YouTube Mathematics, and you can see a recent webinar where we do talk about the spreadsheets. The spreadsheets are always improving, or at least usually improving. The equilibrium tester is really good if you've done a lot of gifting and you may have a note owed to you by your trust, which is the case with thousands and thousands of wealthy Americans. Then you can use the equilibrium tester to see if you're comfortable where you are now, if you want to do more or less of the installment sales for a trust or a private annuity. And you probably don't know what I'm talking about. Speaking of not knowing what I'm talking about, I've got some definitions here. So some of the things that we want to pay attention to in estate planning, and quite candidly, we forget to mention these things because we get so into the mathematics of the estate tax. Probate and percentage fees. What's probate? Probate is what it takes to get an asset out of a deceased person's name to where they wanted it to go. If it's in their personal name, then the court will oversee the process of appointing an executor or executrix or personal representative and allowing the transfer to a trust or to a beneficiary. And as you can imagine, there's a lot of red tape involved because the court wants to make sure that the creditors get paid, the taxes get paid, more importantly, the lawyers get paid, and the personal representative gets paid. So it can take months, sometimes years. Usually it's months. When it takes years, either people are not really in a hurry or there's messes that we're cleaning up. So yes, probate can be expensive. Quite candidly though, a lot of the expense of a typical long probate is that the person did not have their affairs in order. And I'm not talking about their romantic relationships. I'm talking about their trust documents, their corporate documents, their tax returns, their buy-sell agreements. They go and so rudely die, leaving everyone to wonder where all the paperwork is and what they had and what they intended and how to unwind their relationships. So it's best to be organized. That is part of estate planning. It's a pleasure to do estate planning for retired military officers because it's all done well before they die and they update it every week. On the other hand, for entrepreneurs and college professors, not so much. The percentage fee is permitted under the statutes of many states, where if you appoint a trust company or maybe a lawyer or a CPA to administer your estate, then the statute allows that person or that company to charge a percentage of the estate. Now, sometimes that is not reasonable because there's not a lot of work and the percentage is a lot higher than what the work is worth. Sometimes it turns out to be reasonable. But in your estate planning, in your documents, you can address this. If you want whoever does the work to get paid on a reasonable hourly basis, you can make sure that that happens. And you can try to avoid probate by having assets held in a revocable trust or having assets held where they pass on death by pay on death or beneficiary designations, which we are going to talk about. So those are two of our definitions for today. Another definition is what is a trust? And a trust is an agreement between a trustee who has a fiduciary duty to follow the terms of the trust agreement, and the settlor or the grantor, that's who sets it up. And then there's the beneficiary who benefits from the trust. So I enter into a written trust agreement with my CPA. I appoint her to be the trustee of the trust. The trust is for my granddaughter, and I give assets to the trustee to hold for my granddaughter. And that is a trust agreement. So a trust is not technically an entity like a company. And you shouldn't do a deed from yourself to the John Smith Trust. You do a deed from yourself to Rose Dean as trustee of the John Smith Trust. So a lot of mistakes get made. That's a reason to use a qualified lawyer as opposed to doing it yourself. Now, there's two kinds of trusts if you look at it this way. There is the revocable trust, which I can change anytime I want, and which is considered as owned by me for creditor purposes and for estate tax purposes and for income tax purposes. And then there is the irrevocable trust. Now, it has nothing to do with my ears or hearing. My ears get bigger and my hearing gets worse, but my irrevocable trust stays the same. That's why it's spelled with an I in the beginning and not an EYE trust. Okay. The irrevocable trust, when I set it up, I cannot change, but I could appoint trust protectors to change the trust. Trust protectors are people or institutions who could have the power to change a trust. Otherwise, a trust cannot be changed by the grantor. Typically, it cannot be changed by the beneficiaries, but under state law, after the grantor dies, the beneficiaries and the trustee may have the right to unanimously agree to change the trust, which would cause the grantor to spin around in his grave because he didn't want them to change the trust. So you may have special provisions in your trust to prevent it from being changed around after you die. So I've covered what is a trust, what is a revocable trust, and what is an irrevocable trust, an irrevocable trust. And then there's another quadrant of trust definitions. There's a trust you set up while you're alive, and that is called, believe it or not, a living trust. And Latin for living is inter vivos. So a living trust, a trust you set up while you're alive, whether revocable or irrevocable, is an inter vivos trust. And a trust that arises on your death, with or without nitrous oxide or helium, is a testamentary trust. So if you ever take a test about this, remember that a trust that arises upon death from your will or possibly from another trust is a testamentary trust. And most well-drafted trusts have a spendthrift clause. And with a spendthrift clause in place, a beneficiary of the trust cannot sell, assign, or pledge their right to be a beneficiary to a creditor. So I die and leave a trust for my granddaughter, and the trustee has the ability to give her distributions as the trustee deems appropriate. And my granddaughter wants to borrow money to buy a horse. It's a pink horse and it talks because she's 4 years old. Well, the bank will not loan her the money to buy that talking pink horse because she can't pledge her interest in the trust because there is a spendthrift clause. Now, Separate and apart from your will is the living will, and that is the document that allows life support to be withdrawn, which is confusing because a living trust has nothing to do with life support, and a living will has nothing to do with a last will and testament. So page 24, F. Lee Bailey's rule, any person who does his own legal work has a fool for a client. And F. Lee Bailey proved that when he went to jail for violating trust account rules. From our Saturday, July 9th presentation, Estate and LLC Planning, Fun with Dick and Jane, you all remember it. I know you all cried when Spot the Dog came on and saved the day, but one simple estate plan is Jane's estate plan. Jane has a home, a brokerage account, a bank account, and her daughter, Sally. So she makes Sally the beneficiary of her IRA, and that's all Jane does. Jane dies. The court appoints a personal representative to hold the assets for Sally. When Sally turns 18, she can demand the assets. So Jane would be well advised not to leave the assets directly to Sally. So Jane signs a will with a testamentary trust. Testamentary, it opens up on Jane's death, and on Jane's death, the IRA is payable directly to the testamentary trust. The home may pass directly to the testamentary trust if Jane signs what's called a ladybird deed, which like a pay on death deed. Although in Florida, if Jane dies and has a minor child and a home in her name or in her revocable trust, the home immediately vests in the child. So when the child turns 18, they're going to do whatever 18-year-olds would do with the home. So Jane could make her brokerage account and her bank account payable by pay on death designation to the testamentary trust under Jane's will, so that they would not have to go through probate, even though she doesn't set up a living trust. So it's a real headache, and we see a lot of mistakes made or carelessness when someone signs a will that says everything goes in trust for my child, and then they forget all about that, and they open a brokerage account and they put their child's name on the pay on death account. And we look at the will and say, oh, it was obvious that you intended that asset to be held until your daughter was age 30. But unfortunately, it's going to her at age 6. So now we have to get a guardian appointed by the court. The guardian has to administer those assets. And when she turns 18, she gets what's left. So that's the story of the will and the testamentary trust. So I guess that's estate plan number 1. Estate plan number 2, Jane sets up a revocable living trust. It's the Jane Smith Revocable Trust. And Jane puts the title, the brokerage account, and the CD, and maybe her home, and her IRA gets payable to the revocable trust. Now, if Jane becomes incapacitated, we don't need to appoint a guardian to oversee the assets that are in the trust. Jane's alternate trustee named in the trust agreement takes over. No need for a guardianship as to those assets. Everything stays private and outside of the court. And when Jane dies, Jane's successor trustee can simply take a copy of the trust and Jane's death certificate down to the bank and say, Jane died, please give me the money. I'm the trustee of the trust, and I'll hold it pursuant to the trust documents, which say I will hold it for Sally until Sally reaches age 30. Now, Jane could put her home in the revocable trust, but if you do that in Florida and your child is a minor, or you have any child who's a minor, then the home passes by our archaic Constitution, which says it goes directly by operation of law in equal shares to the children. There's an exception if you are in Florida and you own the home jointly with right of survivorship with somebody, then it will pass with right of survivorship. So if you have minor children in Florida and you're married, you typically have the home owned jointly with right of survivorship with your spouse. Otherwise, if it has to go to your minor children, you might just mortgage it to the hilt, so there's not much equity that the children can get. So that is the second estate plan in the world according to Jane. Now, if Jane gets a life insurance policy, she may want to own the policy to keep it creditor proof under Florida law, but then have it payable by beneficiary designation to her trust. And of course, the trust needs to have the proper operating language. Estate plan number 3, if we're counting them, is a revocable trust with a safety latch provision. A calendar quarter does not go by when I don't see a new situation where an elderly individual had a will or a trust and came under the influence of an aggressive person who encouraged them to change their will or trust to favor that person. So when a client comes to you and says, I have 4 children, I love them all, Matilda has problems getting along with people and has never really been able to make it financially. And I don't always get along with Matilda. The other 3 children are great. Okay, well, what happens when this client has a stroke? She needs help, and Matilda moves right into the house. And it's an act of generosity on Matilda's part to take care of her mother. Matilda needs a place to live anyway. And then Matilda brings the mother into the lawyer's office, and the mother announces that she wants to leave everything to Matilda because Matilda has been so good to her. We see this time and time again. Why there are so many people named Matilda, I will never know. So the safety latch provision may prevent that, and in many cases has prevented that. The safety latch provision says this is a revocable trust. I can amend it anytime I want, but once I have reached age whatever, or if I've ever received a diagnosis of dementia, or any time whatsoever, depending on how you draft it, no amendment to this trust will be effective unless it's approved by 3 of my 4 children, or my longtime medical doctor, or any 2 board certified psychiatrists and/or neurologists. So now when Matilda's daughter moves in, takes Matilda to a lawyer, the lawyer says, hey, I'm sorry, you got to get approval of your siblings or the family doctor or a couple of psychiatrists. And at that point, the aggressive child may stop being aggressive, may steal money out of the trust, but at least this could be a safety precaution. I do strongly recommend it because we've seen it work many times. I've given you sample language. Please give it some thought. So that would be estate plan 2.1. Now, estate plan 3 is the client who comes to you and says, I don't have much, or I have something, but what I mainly have is the expectation of an inheritance. And you say to the client, well, tell me about yourself. Well, I'm a neurologist. I get sued at least 3 times a year. I got divorced. I don't have many assets left. I am relying upon the inheritance I will receive from my mother in order to be able to retire. So you say to this neurosurgeon, we would like your mother to amend her will to provide that on her death, the inheritance will not go directly to you. It will go into a trust. You can be the trustee of the trust. You can receive whatever you need for, magic words, health, education, maintenance, and support for your lifetime. You can direct how the trust assets pass on your death with minor constraints. And if those requirements are satisfied, your creditors cannot reach into the trust. The trust will not be subject to federal estate tax when you die, and the trust will be generally safe from divorce claims. So, of course, neurosurgeon calls his mother or her mother and says, Mom, I need you to do this. And then, quite candidly, it hardly ever gets done. Mom says, well, I'll call my lawyer, and then Mom's lawyer doesn't quite know how to do this, and then Mom doesn't call the lawyer back, and Mom doesn't want to pay $3,000 or $2,000 to have her will and trust amended. So my strong suggestion is that the neurosurgeon has his lawyer prepare an inheritance trust. And the inheritance trust has all the language that the neurosurgeon wants. It allows the neurosurgeon to benefit. It allows the neurosurgeon to be the trustee. It allows the neurosurgeon to benefit his spouse if that's what he wants to do. It allows the neurosurgeon's children to benefit if the neurosurgeon predeceases his mother. The neurosurgeon signs the trust on behalf of his mother, and then the mother's lawyer only has to do one thing: a simple trust amendment or codicil, which says the inheritance that was going to my son Mortimer will instead go to the Mortimer Jones Inheritance Trust. That's it. That's a very simple trust or will amendment. So that inheritance trust needs to have all of the right language. I've indicated in my Forbes blog a lot of the language that's there. Don't do this at home. If you've never done one of these, it can take quite a few hours to put them together. Those of us who have done a few of them, it doesn't take as long on the 20th one as it took on the third one, but it still takes some time to have it customized to your situation. So that's the inheritance trust. That's estate plan number 3. But who's counting? Now, estate plan number 4 is a typical married couple estate plan. The first thing I recommend is that you keep the marriage together so that you can do a married couple estate plan. The second thing I recommend is that if you are in a tenancy by the entirety's estate, or you have seen the cartoon Tennessee Tuxedo, you ask the lawyer whether your assets should be owned separately under revocable trusts, under a joint revocable trust, or jointly as tenants by the entireties. And some of the states that recognize tenants by the entireties and give foolproof creditor protection to tenancy by the entireties are Florida, Delaware, Wyoming, to a great extent Tennessee, to some extent Pennsylvania, and there's other states as well. So mostly there is the state of confusion, though. If Marcia and I, that Marcia's my wife, if we own assets as tenants by the entireties, then if somebody gets a judgment against one of us, they can't touch the tenancy by the entirety's assets. So if somebody got a judgment against me, maybe they sue me because my puppet was driving too fast and got in an accident and hurt them, then I could file a bankruptcy and get rid of the judgment and not lose any of our tenancy by the entirety's assets. So many lawyers properly recommend that each spouse will have a revocable trust. For example, my office building, Marcia's office building, is owned by an LLC that's primarily owned by Marcia's revocable trust. So if Marcia predeceases me, that trust becomes irrevocable. I'm co-trustee with my choice of a person named in the trust agreement or a trust company, not someone who I may meet in the future. And the trust is for myself, our common descendants named in the trust, and it's not going to get lost. It's not going to be taken by a future spouse or lost in a card game or something like that. On the other hand, if we own everything jointly with right of survivorship and she dies, then everything's now in my name and unprotected. So it's a real art and not a science. And art, if you're listening, you should know this, to decide not only what documents you need for the trusts, but also how to title, what to title into each trust or what to title jointly. Now, one thing to keep in mind is that if a spouse dies with tenancy by the entireties, the surviving spouse can disclaim, what that means to renounce, to say, I don't want to inherit his half. Let it flow through his probate estate into his trust to benefit me for my lifetime. So that's why revocable trusts and wills are often drafted with disclaimer provisions. In addition to my trust and Marcia's trust and our tenancy by the entirety's assets, we can establish irrevocable trusts, which can benefit our descendants and hold life insurance to avoid estate tax on life insurance. And as you probably know, if you've seen enough of our videos, spouse one could fund a spousal limited access trust called a SLAT for the benefit of spouse two and the descendants. Spouse two can be the beneficiary as long as her ability to receive benefits is limited to what she reasonably needs for health, education, maintenance, and support. That trust will be outside of her estate for estate tax purposes. Or if you live by the sea, it could be estate tax porpoises. Porpoises cost about $750,000 if you're able to buy one in captivity and get a license. And you could put the porpoise that you buy for your spouse into a spousal limited access trust along with a lot of fish, because porpoises eat a lot of fish, and they go click, 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 click. Okay, it's a little bit off the subject, I guess. Now, this is estate plan 4, I think. Estate plan 4.2 or 4.1 is your layered entities. So now, how we could set up an LLC owned partly by us as tenants by the entireties, partly by a trust for our children. Why would we do that? Well, not because we like our children. Many times we may not. So, but if you get a judgment against both of us, or one spouse dies and there's a judgment against the other spouse, if there is another owner of the family LLC, in most states, the sole remedy of the creditor is something called a charging order. And a charging order only allows the creditor to get paid if and when there's a distribution from the LLC. So it puts you at a stalemate with the creditor. So, and then here, if I'm a control freak and I want to put $10 million into a lifetime SLAT for Marcia, but I want to control it, then I make her the trustee, but she invests the $10 million in an LLC, and I could be the manager of the LLC, and then I have a fiduciary duty to manage it properly. But these would be a couple of examples of subsidiary entities. Now, what happens after death of the owner of a living trust. And my partner, Christopher Denicolo, has been working on this exhibit, which I think came out really well. So the living trust on death divides into a credit shelter trust or family trust that can benefit the surviving spouse without ever being subject to estate tax in the surviving spouse's estate. And then if the living trust of the first dying spouse has more than $12,060,000 in it, then the excess can pour over to the surviving spouse or can pour into a Q-tip trust, which has nothing to do with cleaning your ears. Q-tip trust stands for qualified terminal interest property, and anything over $12,060,000 to avoid estate tax on the first death will go to the Q-tip trust. The Q-tip trust has to pay all income to the surviving spouse and qualifies for the estate tax marital deduction, which means there's no estate tax on that trust. Now, when the surviving spouse dies, the Q-tip trust assets are considered to be owned by the surviving spouse for estate tax purposes. But this is what most revocable trusts will break into on the death of the first dying spouse. Now, what happens on the second death? On the second death, the family trust can become a generation skipping trust for the surviving descendants. So what does that mean? That means that when the client passes away, that surviving spouse passes away, generally and usually, the assets in that family trust divide into separate trusts for each child. Each child is the beneficiary of the trust, along with their own children, and the trustee of that trust. And the child can receive amounts as needed for health, education, maintenance, and support, and can direct where the trust assets pass on the child's eventual death, although usually this is limited to being directed to descendants of the original grantors. Most clients, in my experience, want to take care of their descendants and no one else. It doesn't go to in-laws, it doesn't go to outlaws, it doesn't even often go to charities. It has to stay in the family tree. So that keeps the family from living in trees and is sometimes intriguing. So that is the generation skipping trust. It causes me pain to open up a trust agreement and see that it says, I leave this trust for my spouse. On my spouse's death, it goes outright to my children if they have reached age 35. Well, you're pouring money, you're pouring gasoline on the fire of a divorce, the fire of a creditor situation, the fire of a gambleaholic, and putting estate tax on it, causing it to be left when that child dies to a spouse or significant other than the grandchildren or grandchildren, because nobody thought about it that way. So that's what's nice about the inheritance trust and the GST trust. The reason we call it a GST trust is because we can charge more for it when it has the name GST trust. Oh, thank you. Thank you. I thought that was funny too. All right. So, but it doesn't, the trust doesn't skip benefiting your children. It skips estate tax when your children die. Now, what comes out of the Q-tip trust usually will not beat the estate tax when the children die because it's called a non-GST trust, but still it can protect the children from creditors, divorce, and their own misfeasance or malfeasance, depending upon the situation. So that is estate plan number 5 or 6, I don't know. I've lost count. Now, July 13th, I've discussed the jest, and I want to mention it because it is an alternative estate plan, and I've only mentioned 5. So number 6 is the jest, and I'm not jesting. It stands for Joint Exempt Step-Up Trust. So instead of owning the assets jointly with survivorship or owning the assets in separate revocable trusts, Marcia and I could set up a joint trust, which has a lot of complicated language, which basically says when one of us dies, it all locks up into separate trusts, and 2 things happen. One thing is that we design and draft the trust so that all the assets in the trust get a new fair market value income tax basis on the first death. So for example, if we have $5 million worth of Apple stock that we paid $500,000 for, one of us dies, the survivor needs to sell it, you normally pay capital gains tax. You don't get a step up on all of it. But if it's in a jest trust and it's properly drafted and administered, then we believe, and many practitioners believe, that you get a full step up so the surviving spouse could sell the $5 million worth of stock for $5 million, the date of death value, no capital gains tax up to the date of death value. Secondly, it all locks up in the trust. So one spouse dies, they don't have to worry about the surviving spouse giving it to the next spouse, which is very important, of course. So the joint exempt step-up trust can also be a good creditor protection arrangement because, for example, if I'm the neurosurgeon and Marcia is the soccer coach, I could own 1% of the joint exempt step-up trust. Marcia could own 99%, yet on my death, it still all locks up and gets the step-up because of the way that we have designed it. So you can Google Gassman Jest and Estate Planning Magazine. If you Google that, the articles that we published, I think about 20 years ago, or about 10 years ago actually, come up, and we have not encountered any body saying that the jest won't work, and in practice, they have been working fine. Don't blame lawyers who don't use them or don't know about them, because they're just not in the mainstream. For some lawyers, they are. And then there are theories that the IRS may use to not give you your step up on death. And we've quoted articles by very good authors explaining potential issues. But we think it's more likely than not that it will work. And as a practical matter, they have been working quite well. And then if you want more creditor protection for your jest, you could have the jest trust own an LLC and have it partly owned by a trust for those descendants, whether they deserve it or not. And then if somebody got a judgment against the spouse who owns most of the jest, they would be limited to a charging order, so at least there would be a stalemate with the creditor. Now, sometimes for elderly or frail clients, we are afraid that their children or somebody will come in and get aggressive and take it away. So for those clients, we have prepared irrevocable jest trusts for the benefit of the clients, yet irrevocable. And I've read articles that say that people make their best decisions in their 40s, 50s, and 60s, and that decision making is not as good in your 70s or late 70s or your 80s. So the question is, you have health risks, you have aggression risks, and you're competent at age 60. Do you make it irrevocable? But more often what we see is the client is in their mid-80s, they are frail, and we recommend, even beyond the safety latch, let's go ahead and put it in an irrevocable trust. The trust can be revoked only with the consent of a bank trust company and your trusted advisors or 3 psychiatrists, or it's absolutely irrevocable even though the client is a beneficiary. Now, that doesn't help anything from an estate tax standpoint, but it doesn't have to hurt either if you make it an incomplete gift irrevocable trust, which is a trust that's irrevocable under state law, but still considered to be owned by the client under federal estate tax law. It's not easy to draft these, but it will save a elderly or infirm person's assets. And we've done these with clients in their 30s who have had issues with addiction, issues with mental situations, issues with aggressive family members. So we put millions and millions of dollars into irrevocable trusts, which benefit the client who set it up, but are very difficult to lose in a card game or in a bad marriage or whatever you have. Sometimes if there's 2 children, we'll go ahead and set up irrevocable trust 1 for child 1 and trust 2 for child 2. In one situation, trust 1 was a business owner and the child 1 was running the business. Trust 2 was the buildings that the business leased from, and child 2 ran the building leases. And the clients wanted child 1 to inherit the building and child 2 to inherit the business, vice versa, and wanted to be darn sure that that wasn't going to change. So I guess I'm not sure why Mark Twain was there. Maybe never the twain will meet, something like that. I don't remember. Had nothing to do with Marxism. But think about that when you meet with your clients. If they are infirm, go ahead and put it in an irrevocable trust for the client. The son may manage it with a fiduciary duty, but have no right to withdraw any assets until the death of the surviving spouse. And that may work very well. So that would be estate plan number 6 or 7, depending upon whether you're counting or not. So the next estate plan would be fairly simple, just to show you a alternative, and that would be instead of dividing the assets equally between 2 living trusts, where when one spouse dies, they want half the assets to lock up, go ahead and set up an irrevocable trust for the children and have the irrevocable trust for the children own a small piece of each of the family LLCs, so you'd have charging order protection on death, and then a better discount for valuation purposes on death for federal estate tax purposes, because each trust only owns 49%, not even 50%, and 49% of a $10 million asset is worth a lot less than $4,900,000 because of minority discounts or non-voting discounts. So that gives me estate plan number 7 pretty easily. Estate plan number 8 or 7, or who's counting, is something we were working on very recently, where the client wants to go ahead and divide the assets between 3 very responsible children now. And this makes great sense because the client has 3 different businesses or 3 different types of buildings, and each child would like to be responsible for this particular building or this particular business, and would quite candidly be more responsive if they knew it was coming to them. And the client doesn't want to pay federal estate tax or lose these assets in the event of a creditor calamity. So what we've done for the 3 children is we've creatively called these child trust number 1, child trust number 2, child trust number 3, and a trust for the grandchildren. And we go ahead and place the assets that they want to go to child number one in holding LLC 1, and then of course for child number 2 in holding LLC 2, and in for child number 3 in holding LLC number 3. So what happens is we have an irrevocable trust for child 1. Child 1 is the trustee but could be replaced at any time by the client while she's alive. The child can be the manager of holding company 1. So you say, okay, here's the building. Do your best. We're watching. Whatever's left when we're done, you inherit. So we hope you do a good job. Take a reasonable salary. If you don't do a good job, we're going to take you out as trustee, take you out as manager, and somehow find a way that your children will inherit this building, not you. So you better toe the line. But the future growth in the building is going to be out of the estate for federal estate tax purposes. But the client is interested in getting the growth out and to get some value out of their estate, but they would like some of the cash flow to continue to own. So what we do is for child number 1, let's say that this LLC is worth $10 million, and therefore 99% non-voting may be worth $7 million. So what we might do is make a $700,000 gift of cash to this child number 1 trust. We call that a seed capital gift. And then the client will sell the 99% non-voting member interest in the LLC to the trust in exchange for a $7 million note. If we do it this month, it's going to bear interest at about 3%. So the client has converted a $10 million asset, or at least 99% of a $10 million asset, into a $7 million note. $3 million vanishes from the estate tax system, and the client will receive 3% of $7 million every year, $210,000 a year, rain or shine, and the client will pay the income tax from the income of the LLC as long as they want to. So that income tax could be $200,000 or $300,000 a year, which will further reduce the client's estate. And why is there a grandchild trust? Well, because everyone loves their grandchild. And also, we don't want the client or the child trust to have the right to liquidate the LLC or to determine when to make a distribution from the LLC, because if the trust has that right, you can't get your 30% discount or whatever discount you get. And if the client has that right, then the IRS will claim under Internal Revenue Code section 2036A2 that the client should be subject to estate tax on the total value of the LLC on the client's death. Under the Strangi case, S-T-R-A-N-G-I, and the Powell case, P-O-W-E-L-L, and the Cahill case, C-A-H-I-L-L, you can Google them and read them. They're great for bedtime stories. So we have one grandchild trust that owns 0.1% of a special voting member interest, and we have the client holding 0.9% voting, and the trust receives 99% non-voting. Now, we need to have the properties under these LLCs, we believe, safely, to be safe, more than 30 days before the installment sale occurs. We got a step-by-step thing here. So lawyers, accountants, and financial planners, if you're still awake, isn't this a nice way to explain what you're doing to the client? And I don't mean what you're doing to the client. I mean to explain what you're doing to the client. And quite candidly, it takes time to put these exhibits together. These are Excel documents. And while the secretary excels at doing them, on purpose, it does take some time. It's worth the effort. And for some clients, we would draw a cartoon. So the first step would just show before the sale, The grandchild trust owns 0.1%, the living trust owns 99.9%, and then you show the sale. But what's exciting is you say, look, the $10 million building in 10 years will be worth 20 million, and in 20 years rather, will be worth 40 million, and the parent still just has a $7 million note. You liquidate the LLC, the trust gets 99% of 40 million, pays the 7 million note, and $33 million is outside of the estate tax system. If the parent gets sued or does something goofy with the promissory note, that may be lost, but that 33 million of equity is locked in for the child. If the parent gets mad at the child, the parent could appoint Attila the Hun. For those of you who don't know who Attila the Hun is, she was a famous Broadway actress in the 1930s. She could be the trustee, and she might only favor the grandchildren, but at least it's not going to go to a new second spouse of the grandparents or something like that, or heaven forbid, a tax lawyer or CPA who might inherit it. So that is estate plan number 8. Now, estate plan number 9 is one of my personal favorites because it works so well. The client was having a potential creditor situation because of issues in the real estate markets in 2005 and early 2006, and I think you all know that everything went off the cliff in 2008, 2009. And the client liked a particular offshore jurisdiction, not necessarily the Caymans, and also was somewhat interested in avoiding federal estate tax. So he had an income producing asset that he did not want to lose if his other situation became bad. So we set up a grantor retained annuity trust offshore, and the trustee of the grantor retained annuity trust was a reputable trust company that this family had been dealing with for many years. And the client put the non-voting member interest in his holding company into the GRAT in exchange for the right to receive annual payments for a series of years. And we drafted the GRAT to provide that these annual payments would be considered an annuity under the Florida statutes, which say that creditors can't touch annuities. And also, we provided in the trust agreement that the trustee had the right to pay those payments either to the client or as deemed appropriate for the client's benefit. So we set that up for estate tax purposes. One of my favorite things about this is the client never would have done this if he didn't have the concern about creditors. But this was a very genuine and very effective estate tax planning tool. Well, things didn't go well. The client, unfortunately, became insolvent, and the creditors looked at this and said, well, let me see. Number one, this may be protected under Florida Statute 222. Number two, if a judge says it's not, we've still got to go to the offshore jurisdiction, get a judgment in the offshore jurisdiction, which doesn't recognize U.S. judgments. And then we see a flee clause in the grantor retained annuity trust. By the time we get our judgment in the foreign jurisdiction, the assets may all be liquidated and moved to another jurisdiction. So the matter was settled for nickels on the dollar, not pennies on the dollar, but nickels. And everything went very well after that for the assets that were placed under the GRAT. When the client passed away, the family had no estate tax, and they would have had a lot of estate tax had it not been for the financial crisis. So the real moral of that story is, you know, good thing, bad thing, who knows? Some things that are bad turn out to be good. if the economy hadn't buckled and he hadn't lost all those other assets, then his family would have paid a lot more estate tax than he lost in the creditor calamity. So it was good that he did the creditor protection planning, and it was good that he did the estate tax planning. There were excellent business reasons for the arrangement, and that is estate tax number 8, I think. Okay. I must be a really good estate tax lawyer if I can't count to 10. The mathematics of estate tax presentation that we gave May 28th had a fairly typical arrangement. The clients come to you and they want to do estate tax planning with this many assets. Husband has $1.9 million, joint assets $3.4 million, wife has $3.9 million, and they want to freeze this thing and discount it as best they can. So they contribute all these assets to an LLC, and the relative contribution is 39.9% by the husband, 60.1% by the wife. That's just the way the math works out. The husband sets up a trust for the wife and children called a SLAT and sells a 39.4% interest in the LLC, non-voting, to the SLAT in exchange for a $2.8 million note. So he's put in $1.9 million plus half of $3.4 million, which is about $3.6 million, and we've converted that to a $2.3 million note. He also makes a seed capital gift to the trust, and all this happens and the LLC is funded more than 30 days before the sale. The wife does the same thing with her share. She decides she doesn't want the husband to be a beneficiary of her trust. We don't want something called the reciprocal trust doctrine to apply. So now we've converted that much in assets to much less in assets, low interest promissory note, the same type of thing. And you know, clients often ask me, well, what should I freeze? And my answer is discount and freeze everything you can. So often clients come to us and they've done all this planning on like 1 or 2 assets, but why haven't you done it with everything? If you're going to have an estate tax issue, there's no crime in your net worth consisting of a home or a qualified personal residence trust, ability to hold a home, and promissory notes, bearing interest at low rates or higher rates, and the promissory note is a self-canceling installment note. So, and we have information on qualified personal residence trusts. Let me just skip to estate plan number 10, using the Estate View software, which we designed with Professor Jerry Hash and my son-in-law, David Archer, who is a brilliant financial and software designer. So this is Bob and Mary Sample, creatively named. And Bob is, let's see what Bob is 63, and he's got a life expectancy to 2039, but doesn't smoke and he exercises, so we'll let him live to 2042. And Mary is 60, and she's going to live until 2047. Their home is worth $1.5 million. It's going to grow at 3.53% a year. Or, you know, if you want to grow it slower, we could just grow it slower. Their assets are $15 million. They're going to grow at 8.23%. Part of this is a business which is doing well and will continue to do well. And we will assume that the lifetime estate tax exemption will not drop in 2026, and that when one of them dies, if the survivor gets part of the unused estate tax exemption not used by the first dying spouse, that it's not lost. They have 4 children, and they'll gift the $16,000 a year as it grows with inflation each year, and they'll gift discounted assets. They'll gift LLC interest at a 35% discount. They have no life insurance, and let's see where they are. If they do no planning and they die this year, then there's no estate tax because they're only at 16 million or 17 million, and their exclusion is 24 million. So there's no estate tax. So it's okay to go on vacation. But on the other hand, if they live to the life expectancies I've shown you, hold on to your hats, their estate tax will be $35 million. That is the time value of money. The home growing at 2.7% is worth $2.6 million after Bob's death and $2.9 million after Mary's death. And the investment portfolio, and by the way, there's another number here. They are saving $500,000 a year while Bob is living and $100,000 a year while Mary's living. But if you want me to, I could move that down to say $300,000 a year, and all the numbers move as you see. So, but now they still have $28 million in estate tax, $115 million. That is the time value of money. Well, we know that on the first death, they can put assets into an estate, into a credit shelter trust that benefits Mary and is never subject to estate tax on her death. How much can we put in the credit shelter trust? Well, I'm asking the computer to tell me, and the amount by the time that Bob dies, assuming inflation at only 3%, he could put 21 million in the credit shelter trust, and I click here for bypass trust. And now the estate tax is down. See, without planning, the estate tax was 28 million. With the bypass trust, it's gone down to 25 million. It's not of significant help in their situation, but it is of some help. And that's the bypass trust that gets funded on Bob's death. Now they're going to do annual gifting. So we're going to click on annual gifting here and see what the annual gifting is going to save us. And that gifting trust is going to be worth $12 million on the second death that escapes estate tax. We've got the estate tax down to 20 million. That assumes that they gift cash. If they gift discounted LLC interest at a 35% discount, then they're going to get that estate tax down to 17 million. So that discounted gifting saves 3 million of estate tax, but they still have the estate tax. So now I want to talk to them about setting up a SLAT. So what I want to talk to them is they put $1 million now into an irrevocable trust for their children, and they put $11,500,000 into an LLC, and they sell the 99% interest in the LLC for an $8 million note, and the note will bear interest at 3% or 3.25%. So now I click on installment sale and no tax. So they may think I overshot it. They may say, well, how much of an installment sale do I need to do to have no tax? So then I can just back the number up here. I can reduce the installment sale, and I see I was pretty close. The tax, I need to put about 10.6 million into that installment sale in order to reduce their estate tax to zero. Now they may say, what happens if we die early or later? I can go, oh, by the way, if you'd like to have a copy of a letter that explains this plan, I will click Generate Client Letter, and now the computer is drafting the letter, and there's the letter. The letter explains all of the inputs and explains the techniques and provides the charts that you saw there. It's not perfect. We're always pulling bugs out of this thing. That's why we sell this for only $79.95 instead of $1,095. But anyway, I'll send you the letter. If you'd like to see the letter, just put letter in an email you send us. But now, for you planners, if I go to the timeline, this is showing me, and for example, if I go to the timeline with bypass trust, this is showing me that there will be no tax if they both die by 2028. But if they live to 2030, that's when the estate tax, and the red is the estate tax amount. But if I do discount, so the yellow there is the credit shelter trust that gets formed when Bob dies. That's when he dies. And the red is the estate tax if they both die. If I do the discounted gifting, it gets a little bit better. If I do the installment sale, it goes away. Now, if Bob dies earlier, I just move the line over there and we see what happens if Bob dies earlier. Or if we want Betty to die before Bob, we move the line there. So, I mean, David just did a great job on this. Next week, I will review the installment sale calculator when we talk more about the math, which shows how an installment sale works and how a single individual using an installment sale can reduce federal estate tax. Okay, well, I hope that you enjoyed the program. I know that Dummy McPuppet did. No, I didn't. It was very boring. Okay, well, I'm getting a new puppet soon anyway. No way. Yep, I am. You're going to go to part-time status. No. I want to be the puppet. No, you're not going to be the puppet anymore. I've got a new puppet, one who appreciates me. So thanks again. We will see you next Saturday and every Saturday, 11 a.m. Eastern Standard Time, whether you want to see this or not.